I am absolutely thrilled you're here today because we're going on a seriously fascinating journey. We are going to track the life cycle of evidence. Think about it. How exactly does a piece of evidence travel from the streets into the hands of the police and finally all the way to the judge's gavel? Well, it's a path that is literally filled with constitutional roadblocks, loopholes, and some pretty high-stakes drama. Now, before we even think about stepping foot in a courtroom, consider this for a second. Can the government break the law just to prove that you broke the law? I mean, if a police officer conducts a totally illegal search and finds a weapon, should they still be able to use that weapon to put you in jail? This right here is the ultimate tug of war between fighting crime and protecting our fundamental constitutional rights. Okay, let's dive right into this. We're going to map out 4 landmark Philippine Supreme Court cases today. First, the birth of the exclusionary rule. Second, the strict limits on stop and frisk. Third, the private citizen exception. And finally, beyond a reasonable doubt. Starting with Section 1, the exclusionary rule, birth of a shield. Let's start with a massive, and I mean massive, turning point for citizen privacy in the Philippines, the legendary case of Stonehill versus Diokno. This is really where the modern rules of the game were written. To really wrap your head around the scale of this case, just look at this number, 42. Back in 1962, an astonishing 42 search warrants were issued against a man named Harry Stonehill and his various corporations. Armed with these 42 warrants, agents basically swept in and seized a sweeping, mountain-sized list of business records, books of accounts, financial files, you name it, they took it. But here's the kicker. These warrants were ultimately struck down by the Supreme Court. Why? Because they were dangerously broad. They were classified as general warrants, which are basically warrants that fail to specify a particular offense, or they don't detail the exact items to be seized. The applications for these warrants just tossed out broad allegations of violating central bank laws, tariff laws, the penal code. It was essentially a massive fishing expedition. Let's move to the timeline and see how this builds our current legal landscape. Before this 1967 decision, the Philippines followed what was called the Mancado rule. That meant, hey, even if the police illegally seized evidence, it could still be used against you in court. Crazy, right? But Stonehill completely flipped the script. The Supreme Court established the exclusionary rule, declaring once and for all that the state cannot profit from its own illegal actions. If the search is unconstitutional, that evidence is absolutely banned from the courtroom. Period. All right, moving to Section 2. Stop and frisk limits, rules for street searches. So we know your home and office are protected from general warrants, but what about when you're just out walking down the street? Picture this. You're standing at Plaza Miranda in Manila. It's a busy place. Suddenly, police officers march up to you, search you, and arrest you. The reason? Well, according to the arresting officer's testimony, your eyes were moving very fast. Believe it or not, that is exactly what happened to a guy named Sammy Mullicat. The police claimed they found a hand grenade tucked into his waistline after they searched him based on this supposedly suspicious, fast-blinking behavior. Now, what's really interesting about this slide is how the Supreme Court draws a hard line between 2 totally different concepts that the lower court had actually mixed up. First, a search incidental to a lawful arrest. This requires that a valid, lawful arrest actually happens first. You can't just search someone hoping to find a reason to arrest them, right? The arrest comes first. On the flip side, a stop and frisk is a limited protective search for weapons, but it absolutely requires unusual conduct and a genuine reason to believe the person is armed and dangerous. So, did Mullicat's fast-moving eyes justify a stop and frisk? The Supreme Court said absolutely not. Just look at the facts here. The police freely admitted they didn't see any bulging weapon on his waistline. He was just standing at a corner, not bothering anybody. And there definitely wasn't a valid arrest before the search happened, because there was zero genuine reason for the search in the first place. Finding that grenade was ruled illegal. And thanks to that exclusionary rule we just talked about, the grenade was totally thrown out as evidence and Mullicat walked free. Which brings us to Section 3, the private citizen rule, the exception. This constitutional shield we've been talking about is incredibly powerful, for sure, but it has a fascinating twist. Let's walk step by step through the case of Andre Martin. He goes to a private export agency in Manila to send 4 gift-wrapped packages to Switzerland. He says they're full of books, cigars, and gloves. Okay, step 1, he drops off the packages. Step 2, the private agency owner, a guy named Job Reyes, follows his company's standard operating procedure and opens the boxes for a final inspection. Right away, he smells something strange, squeezes a bundle of gloves, and bam, he finds dried marijuana leaves. Step 3, Reyes calls the National Bureau of Investigation. Now, do you notice something missing here? The state didn't initiate this search at all. And this brilliantly illustrates a crucial legal loophole. As you can see on the table, the Bill of Rights governs the relationship between you and the state. If law enforcement conducts a warrantless illegal search, the evidence is stats. But if a private citizen, like the owner of a shipping agency, decides to conduct a search on his own initiative without the cops telling him to, the constitutional protection against unreasonable search and seizure simply doesn't apply. Because the private citizen found the drugs first, the evidence was perfectly admissible, and Marty's conviction held up. And this rule even extends to the digital age. Take the 2005 case of Nuez versus Cruz-Apao. In that case, text messages sent by an extortionist were deemed perfectly admissible because the victim, a private citizen, voluntarily handed their own phone over to the authorities. The state didn't go in and illegally wiretap or intercept anything. A private citizen provided the proof, so the evidence was totally fair game. Finally, Section 4. Reasonable doubt. Standard of proof. So let's say the evidence actually survives this whole gauntlet. It was legally seized, or maybe a private citizen handed it over, and it makes it all the way into the courtroom. What does it take to actually secure conviction? Because remember, just accusing someone is not synonymous with guilt. The state has to clear a massive hurdle called proof beyond reasonable doubt. The Supreme Court defines this as a moral certainty of guilt engendered by an investigation of the whole proof. Now, that doesn't mean absolute 100% certainty because, let's face it, that's practically impossible in human affairs. But it does mean the judge's mind must rest easy upon the certainty that the accused committed the crime. If you look at this chart, the Dramayo case is a perfect example of this standard in action. 7 men were initially implicated in a really tragic murder to silence a robbery witness. But out of those 7 accused, 2 ended up becoming state witnesses. 3 were entirely acquitted because their alibis and the lack of direct evidence created that reasonable doubt we just talked about. In the end, only 2 men were convicted. So the crucial point here is this. Guilt is proven individually, not collectively. The defense actually tried to argue that since the prosecution alleged a group conspiracy, if some were let go, they all should be let go. The Supreme Court wasn't having it. The evidence showed these specific 2 men were the ones who actually committed the act. Even with the co-accused walking free, the individual guilt of the remaining 2 was proven to a moral certainty. As we wrap up this explainer, I want to leave you with a profound warning from the Supreme Court. This is actually echoing from a case that was heavily cited back in our stop and frisk discussion. This is not a police state where order is exalted over liberty. The court essentially said, look, we can't just clamp handcuffs on a person because they have a shifty look. We cannot and will not sacrifice our greatest constitutional principles just to make law enforcement's job a little easier. The journey of evidence is difficult by design, folks. It's meant to be an obstacle course to protect everyday people from the massive, sweeping power of the government. So I leave you with this question to chew on. Where exactly do we draw the line between public safety and individual liberty? Are you willing to give up a little bit of your privacy for more security? Or is the Constitution a firm line in the sand that we should never, ever cross? Keep thinking, keep learning, and I'll catch you in the next explainer.